Time being 7 o'clock, we'll open the meeting of the Zoning Board of Appeals. At 7 o'clock, we have a continued hearing of the matter on 227 Cohasset Street. And at 7:10, we'll be considering and voted on amendments to the rules and regulations, as well as some other matters that the chairman has. I'm David Brown, I'm the vice chairman. I'm just starting the meeting as I was chairing the case that we have. So at 7 o'clock, we had scheduled a continued hearing on administrative appeal of Maurice and Sharon Baudier pursuant to section 10.2.2.1 of the Code of the Town of Foxborough, Massachusetts, chapter 275, zoning, alleging that the town building commissioner and zoning enforcement officer had not enforced the Board of Appeals decision 0319 and certain conditions imposed by the planning board, site plan approval, special permit, and finding of May 19, 2005. With respect to property situated at 227 Cohasset Street in the R40 Residential and Agricultural District. So, we heard this matter last month, and since that time we did a site walk, but because of scheduling conflicts and issues, it was agreed that we would just open and continue this to October 7th. So I would entertain a motion to continue this to October 7th.
Second?
Well, we need somebody to make the motion.
Move to continue the hearing to October 7th.
Is there a second?
Second.
Okay. All in favor?
That's at 8 p.m.
And that's the one that starts at 8 p.m.
And that's right. And I'll make note that this continued hearing starts at 8 o'clock that night. And apparently at 7 o'clock, there's a training session that's going to involve a lot of people. So it may look full when you first get here. Hopefully not. Okay, so I will, and I guess the next matter is we can take up the minutes from our hearing last month. What's the date on that?
August 19th.
August 19th hearing. And I reviewed them. I didn't have any issues with them.
Motion to approve minutes from August 19th.
Is there a second?
Second.
Okay, all in favor? Okay, 3 in favor, none opposed?
5 in favor.
5 in favor, that's right. This is because we have more people here this month. 5 in favor, none opposed. The minutes are approved. So I will now turn the remainder of the meeting over to Bonnie Overett.
So the discussion on rules and regs is scheduled for 7:10, so we've got a few more minutes before then. So let me just bring the board up to date on a couple of matters. First, as I sort of indicated a few minutes ago in talking with Lorraine and Kim, Paige Duncan and I have met with the advisory committee to discuss the several zoning articles that are on the warrant, or the zoning bylaw revisions that are on the warrant for the special town meeting in November, and also the revisions to the sign bylaw that I prepared and that Lorraine talked about last month. The meeting seemed to go favorably, and I think we'll get the AdCom's approval. But again, that's November 15th. The first 6 items on the warrant are zoning bylaw revisions. I think 7, 8, and 9 are road approvals. And then Article 10 would be the sign bylaw revisions. I think there are 17 articles altogether on the warrant, but the first 10 would be, some of the articles would affect us directly and some indirectly. Again, one of the articles that would affect us directly is the proposed definition of habitable floor area, and of course the sign bylaw provisions. Second, as I am sure everybody knows, we've got a 40B application that's coming our way. This is being brought under the local initiative program, which, in which the applicant, which is a couple of companies that are owned by Mike Saig, has requested basically the partnership or the endorsement, support, whatever word you want to use, of the Board of Selectmen. And after a couple of meetings, they voted 4-1 to support that proposal. The next obligation that Mr. Stagg has is to get a project eligibility letter from the Department of Housing and Community Development. I assume that he's already started that process. I don't know for certain. Assuming that he has, I think in theory, DHCD is supposed to either approve or deny that request within 30 days. Again, if meetings are being held virtually or what have you, it may take a little bit longer. So my best guess is that we might get that permit filed with us in December. Perhaps as late as January, perhaps as early as November, but I would expect this winter we will have the comprehensive permit application to consider. There are a number of interesting issues, which I'll save for the time at which we first need to discuss the matter. If you saw any of the Board of Selectmen meetings or have read about the matter in the newspaper, you'll know that there are some residents, both neighbors and otherwise, who object to the proposal. So buckle up. We'll have an interesting time with it. The other matter is, and Diana, you'll probably need to correct me on this. The gentleman who contacted us relative to a billboard on Route 1, he initially contacted Mr. Keegan, is that correct?
Yeah, it's someone that Bill Keegan knows, this lawyer guy. So he talked to Bill Keegan first, and then Bill Keegan referred him to the zoning board. And so he called up, and he's from Canton, but I don't know where the person who owns the land lives,
Yeah.
but it's someone who owns land along 95 in Foxborough.
So I spoke to this individual. He's an attorney in Canton. As he indicated when we spoke, he had been on the Canton Board of Selectmen for, I think, a dozen years, maybe more. He has a client who owns property that, as I understood it, abuts I-95. I didn't ask, and he didn't volunteer who that particular
No, he
landowner
didn't.
is.
He
But
wouldn't say. I was kind of like, where on 95? Like, Cloverleaf, Mechanic Street? I mean,
But the landowner is interested in the possibility of a billboard on that property. The sign bylaw does not allow it. We're only allowed to have billboards on Route 1. And, I explained that to him. He's fully aware of it. And what I suggested is, if his client is still interested in proceeding with the matter, to meet with us relative to that particular matter, to discuss, the various issues that would have to be done. So Diana, you might get a call in November or December to put them on the agenda for the next month.
Barney, if it was in such close proximity to 95, presuming that it was allowed in the first place, would the state need to be involved in that?
Well, state regardless, because after any municipality approves a billboard, before it can be constructed, the party has to get a license from the Outdoor Advertising Board, which is a state agency. But the one question that I have is whether any federal agency, because we're talking about, along an interstate highway, whether a federal agency has to get involved. I just don't know.
That's more of the question I should have asked you.
Yeah, I don't know. I have no idea. So, it's possible that he'll follow through, and it's possible, he won't. And obviously, if he does, we'll talk with him about it, and then we'll, need to make a decision as to whether we want to do something in the way of a signed bylaw amendment. Before I think we would proceed any further than that, I'd also want to talk with the selectmen about it. And that's it for current events that I have. If anybody else has anything? Okay, so
Was
it's...
it something
I'm sorry.
about the German Times or something, did you say?
Yeah, why don't we, because it's 7:10, so why don't we get into the,
Okay, all right.
so, being that I'm retired and have plenty of time on my hands, I took another crack at the rules and regulations, and really my initial intent was to modify the provisions that relate to the comprehensive permits. Number one, they needed to be upgraded or updated. Number two, there were some, I don't want to say they were incorrect references to state regulations. At the time the prior version was prepared, the references to state regulations were correct, just those regulations changed as far as the specific numbering. So I wanted to correct that. Again, there were some issues that did need to be clarified and updated. And as I did it, I looked at some other provisions in the rules and regs that I felt needed to be modified slightly, and that's in really the first 7 or 8 or 9 items. Nothing major as far as substantive changes from where we, have been. I suppose what I could have done was, instead of doing this piecemeal, do it all at once. It might have made more sense. But if the board is in favor of this, essentially what we will have is a completely, or almost a complete rewrite of the rules and regs.
My only question was about the plan of land to accompany applications. You're requiring a registered land surveyor or civil engineer. And sometimes the homeowners don't want to get that deep into that kind of stuff.
We have the flexibility to waive
Especially
that.
the ones that aren't
Yeah.
doing outside stuff,
Yeah,
like
we have
that.
the flexibility to waive that, so I'd rather keep it in there, and at least people know. And if we have to waive it, or if we want to waive it, we can.
And then the only other one I had was about the modification of the comprehensive permit in 20 days.
I'm sorry?
It's on the last page, I think, the modification of the comprehensive permits within 20 days. Theoretically, if they come with that the day after our meeting, we would meet again for a month, which would exceed 20 days.
Yeah, I realize that. This is essentially what the state regs require, though.
All right, so we'd have to schedule a
Yep.
separate meeting for that.
And as you remember, when we had one, I don't know if it was last summer, or I guess it was the summer before, relative to the proposed dog park.
Yeah.
That wasn't within 20 days, but when I spoke with her, she agreed to extend the time. But essentially, this section is a reiteration of the state regs, so.
So going back, are those, that what you got? So the only suggestion I might have is, going back to the situation of requiring the plans, could we somewhere insert the words may be waived by the zoning board or
At their discretion.
something? So it's.
Because a lot of people, they get the plot plan for their house, or they get the septic plan from the Board of Health or whatever, and that's what they draw on. They don't get
Yeah, and we've
totally
usually accepted
redone
those.
engineered plans.
That way there, you're not
Residential
asking them to spend additional money,
Yeah,
to
'cause-
hire now just to get a new surveyor when we already have one
Yeah.
that's from, survey plan from a septic that we can scale from, which actually, I gave one to Diana today for an upcoming case we're gonna have, that I was able to scale on, the new Adobe system.
What would, I'm just kind of do you have any idea, Barry, what it would cost somebody to have, a typical 1 acre lot survey?
I just got a quote from Bill for my lot, which is 1.8 acres, and it was $1,750.
Yeah, so,
I was gonna say 15 to
I'll go
2,000.
well north of 1,000 and.
Yeah, it all depends on what you're looking for, because they can shoot it and give you a value of this is how much it's gonna cost just to shoot it, maybe put those wooden stakes in.
Right.
We've all seen them before with the little orange tags on them. Or they can put what's called stakes in the ground, granite
Yeah,
stakes.
they
They're
start
there
paying more,
forever, way
yeah.
down. So it's all about how much money you wanna spend. It can drive the cost up, so, yeah.
So why don't we add the words under section 2.04A, after the words shall be accompanied, why don't we add unless waived by the board?
Now, when would they ask for it to be waived? They'd have to ask for it to be waived, I guess, before they even file their,
Right, they would, file with Diana, and then we would,
just vote on it.
yeah, just vote on it.
And I assume we would take into account,
So you'd want to vote on it at a meeting? Because that would add time to applications.
Yeah, that's the only way we could do it. That's the only way the
Or
board.
can we
could-
like open a hearing and then,
Yeah, you'd want it before you
Yeah.
had the hearing. You'd
Yeah, but
want
there's no way the board would be able to do anything. So I think the only way we could do it is, again, they file with you, request it. And then
How about
we open-
as applicable or as required, and then they just inquire with,
I mean, especially if
maybe
it's
me.
like those inside things, the home occupations, they're not really doing anything
Yeah.
outside.
yeah, well, and I think that's gonna be in there, that this is really for external to do
The
with the
old,
external
the
additions.
parties, the old one says something about single and two-family homes and then everybody else, so that was what that was, you're replacing. That's how they had it
Yeah.
divided before.
Well, that makes sense, because if it's a single-family home or something like that, then, that's a pretty big expense to incur.
Correct.
Well, it depends on the issue, too.
Yeah.
We certainly want it for a variance,
Right, sure.
and probably for a special permit as well.
Yeah, it's about dimensions, so if we need dimensions, we have to get
Yeah.
it somewhere. It's gotta
Right.
be from, like, qualified surveyor that's stamped and signed and certified, these are the numbers, or even like Diana says, we get those septic ones all the time, and they're not necessarily laying out, dimensions from the home to the lot lines, they're showing dimensions of overall, like your property, just all the corners, but from there, I can scale it, as I
Right.
showed
Meets and
Diana.
bounds survey, they call that.
And I can find the numbers that we need, which will save them the cost of hiring and, a new survey plan. As long as it's something that's a true testament, I can use it, and I do use them regularly for people that are interested in installing pools, that are installing, garages, sheds, things that are totally within their right, that they have, say, 25-foot setback, and it's clear they have 100 feet. I'm not gonna ask them for an updated survey plan, because
Right.
I can easily see with the septic plan that's in our file that they're okay, that it'll
Right.
work, yeah.
Makes sense.
I mean, the only way I can think we can do it is, again, we open the hearing and, Diana, I think you'll have a good sense.
Yeah, I mean, if it's something, like obviously,
Yeah,
something
we
obviously
can
that's
figure it out.
not
Yeah.
close. I mean, if it's something like, they're saying it's 10 feet from the line and I brought out my yardstick, then maybe
Yeah.
something like that. You'd
Yeah.
need
But
something
I think
more
you're right,
accurate.
that for home occupation, we probably wouldn't need it, but anytime we're getting into an issue with a special permit or variance, or even a question about it, we're definitely going to need it. so.
Yeah, you should want, you would want
Yeah, I
that.
mean, usually they have some kind of construction drawing if they're gonna do something, so.
Yeah,
And
So
those
I think-
kinds of things would be recorded at the registry of deeds, they'd have to be proper.
Yeah.
They can't be,
yeah.
You can't take a copy from a septic plan, you'd have to have the plan that's proposed, stamped, signed by that surveyor or design professional, civil
So-
engineer.
That's my suggestion, just to have the unless waived by the board. One other thing, I think in the past, we've required, 8 copies of applications?
Yep.
So what I have in here now is to require 10, and the reason I'm saying 10 is as follows, 1 for each of us, 1 for Diana's file, which would be an official, that's 6, 1 for Barry is 7, 1 for Bob Cutler would be 8, and 2 just in case.
Everybody's trying to reduce paperwork,
Yeah,
not
I know.
create more.
I know. But what I've also put in here is that only, I think 3 copies would have to bear original signatures.
Yeah, that's all he signs anyway.
Yeah.
I think I make him do 4. You, me,
Just in case.
And Bob.
Bob, that's 3, yeah.
Yeah.
Why
So,
not?
I mean, if you'd rather have 8, I'm fine with that too, but I just wanted to make sure that each one of us, as well as Bob Cutler had.
Yeah, I mean, and a lot of stuff I send out electronic now too,
Yeah,
so.
I think within 5 to 10 years, the paper stamped drawings are gonna be gone.
Yeah, Massachusetts allows electronic stamp,
Right.
that's why we can accept it. We couldn't
Yeah.
for a while, we're the last state to allow it through the country. So, to do away with, just to be able to electronically,
I mean, I
which
think
I get
8
regularly from my.
I think 8's fine, if
Okay.
someone come in and wants to see a copy, I usually email it to them. If they really want a hard copy,
Yeah.
I have the big plotter upstairs, I can make copy of full-size plans, so I can print things out, so I'm fine with
And we
keeping
do
it at
the
8.
same regularly. We have all those copies, and, you know, and I'll have stamped drawings from architects, engineers that they'll email over to me, and there's electronic signature on it, which again, it's acceptable through, you know, Mass General law, so.
So Diana, wherever I have 10 in here, 10 copies, make it 8.
Make it back to 8,
Okay.
okay.
And that's all I got, and hopefully I won't do any more.
I think we should have a motion to shut you off on this.
Second.
Oh, in favor of that, too.
What is this? Is this your third strike or
What?
on this?
No, well, the change we made last year.
All right, Bonnie.
Yeah, the change we made last year was because of the publication.
Yeah, yeah, to have them pay the exact amount instead of, because we used to just collect, you know, it was $50 for a long time, then we put it up to 100, and that wasn't even enough.
And again, we talked about this, you know, several months ago. I think we decided the fee structure is relative to other,
Yeah.
you know, other towns, so there's no real reason to,
It works out fine. The people,
Yeah.
you know, I tell them right when they get it, you know, I don't get the bill till later, you'll get it whenever. Sometimes I send it with the decision if I have it, if not. There was one guy I had to chase down, he left the country or something, so his wife blamed it on him. But they did eventually pay it, so if not, I mean, if they really refuse to pay it or whatever, I do have a small budget that I can pay stuff with. It's just the month of June that would mess me up, because if I go past that, then it has to be encumbered and all that stuff, so.
Hey, this is not exactly on this, but I was thinking the other day, since now the legal notices go in the Foxborough Reporter, am I correct?
Yeah, they
What's-
always
What's
have.
left of it,
Yeah.
right? At some point, would it be better if we just switched it over to the Sun Chronicle?
Sun Chronicle's more expensive.
But these are costs incurred by,
It is, but even putting it in the Foxborough Reporter, like if this lady, if she's the only one, she's gonna pay like $300.
all right, well.
Is it the same
it's
paper?
gonna
Because
be-
sometimes the website is like the same web address.
Yeah, but the way that they charge, the price they charge per inch for the Foxborough Reporter versus the Sun Chronicle, there's a difference of like $3 or $4
Wow.
an inch. And this one has to be
That's
published
probably
twice,
regulation.
and we have to put all this extra stuff in it about, it has to be published in some mass newspaper, state website. So we have to put language about that. That adds, you know, 3 or 4 lines. All this Zoom stuff, I try to keep it to a minimum, but,
Well, eventually, it's probably gonna get strangled out the way things are going.
yeah, I don't know how,
And what do towns do when there's no local paper?
then it would have to go to the Chronicle, because that would become the regional paper,
All right.
you know.
Just getting ahead of ourselves.
Yeah.
or if some of the towns around Boston don't have a local or regional paper, it's the
Correct.
Globe or the Herald.
Yeah.
so,
Same thing.
yeah.
Imagine what they must do.
So, anybody else have any other questions or changes or what? So, when do we have a motion to approve it with those revisions?
I would move that we approve with the revisions discussed, the new rules and regulations. And these do not have to go to the town meeting, right? So
No.
it's just a local vote.
Second. Okay, all in favor? Okay, thank you. Time requirements. So, as long as I've been on the board, whenever we have continued a matter, we've always required the applicant to enter into an agreement with us, saying that the matter is continued from whatever tonight is to the next month. I don't think we absolutely need to do that. And the reason being, typically when we get an application, and we're going to hear that application the next month, an application for a special permit, and an application for a variance, the public hearing doesn't have to commence until 65 days after that particular filing is made with the town clerk. We obviously do it much quicker Sometimes within 30 days, sometimes, depending on when the application comes in, it could be just 20 or 25 days. Sometime maybe as late as, 40. A special hearing, a decision on a special permit has to be rendered by us within 90 days following the date of the public hearing, or the date the public hearing commenced. And a decision on a variance has to be rendered within 100 days after the filing was made with the town clerk. It's very seldom that we don't reach the decision within 90 days on a special permit or 100 days on a variance. Occasionally, we are going to be required to continue something, once or twice, but it's been very rare. In fact, the last time I really remember that we continued something at length was the very first decision we had on Normandy Farms back in the 90s. There might have been about 6 hearings on that.
Yeah, that went on for months.
So, as a consequence, I don't think there's, if, for example, we had a hearing tonight and decided to continue it until October, I don't think there's a necessity that we actually sign a document with the applicant saying that we've agreed to continue it. Now, it may well be that Bob Cutler is going to want that, but there's no other requirement that we do so. I think the only time we really need to do something of that nature is when we're going to start to run into problems with the 90-day or the 100-day, deadline. So I think what I want to do is talk with Bob about this and see if we can come up with some other way, if he's in agreement and we're in agreement, or just continue doing what we're doing, but perhaps modify the forms that we have an applicant, sign. Perhaps you remember, it may well be that this is something that first Marie and then Marie Crimmins and then Bob required us to do.
I don't know how it gets started, but I know we used to, I think it used to be, way back, we would force the thing to be done. Which wasn't always fair to us or to them, depending on what it was. We'd fabricate a crisis because of this deadline.
We had meetings that went till pretty late in the night.
Yeah.
But then when Dave became chairman, that's when we decided no meeting should go beyond 10 o'clock.
Yeah. Nothing good gets done after 10.
So again, this is nothing that has to be decided right away. Diana and I talked a little bit about it, and as I said, I want to talk with Bob about it. I'll probably wait till after town meeting, just to see what he thinks as far as handling it. But the one other issue as far as time matters that concerns me, and it hasn't proven to be a problem so far, and hopefully it won't be, is that we're supposed to file a written decision with the town clerk within 14 days of the night that we make a decision. Now, routinely in years past, we would sign decisions at the next meeting, which was obviously more than 14 days. I think we've been doing it more recently, within that, time frame. And fortunately, we don't have, or we haven't had many evenings where we had multiple matters that we decided. So, we were writing 2 or 3 decisions within that period of time. But that's the one thing that I'm concerned about, and it's the one thing that, definitely, if I felt there was going to be a need to have more time, I'd want the applicant to sign an agreement with us to that effect. Obviously, if we turn something down, an applicant's probably not going to agree, but ideally, if I felt it would be necessary to give us a little bit more time for me to draft and for everybody to look at it and then to get it signed, that I would probably want an applicant to waive that time requirement.
I wonder, there's no rush on this, right? I
No.
wonder what other towns do in terms of meeting these deadlines, asking for extensions.
Well, again, these are,
'Cause sometimes we start asking, we find out nobody else ever even thought of it.
Other
Yeah, the-
towns probably meet more than once a month.
these, first of all, these requirements are imposed by state statute. So it has nothing to do with the zoning bylaw or anything of that nature.
I will say, that lady who was in today lives on Idlewild or something like that, so I looked up the old decisions for Idlewild from the 80s, and they do mention continuing for the next month. We had the applicant sign an extension, so they've been doing it
So it's been there.
Yeah.
ever since then.
Did she have a special permit for that building to be built?
Not for that, well, I don't know about, they would probably have a subdivision plan.
Oh.
I don't know, does anybody know where Idlewild is? It's a
Otherwise,
really
up by the
tiny lot.
reservoir,
Yeah.
towards Heaton's boat.
Oh, it's up that
I
way.
happen to remember that because maybe it's somebody that I knew 20 years ago. We used to know somebody.
She's on a corner lot there. She's got a square box, 100 feet, all sides.
Oh, yeah,
The
that's not
frontage,
the one I
not the
know.
200.
I remember that.
Within
Yeah, there's
9
no,
feet of the
there's no
street.
ZBA applications on this particular address, but there are a couple of others.
Oh,
Well,
yeah,
actually,
yeah,
one
near the
lady
water.
kept getting different things on that
You live near the
Idlewild.
water, I'll guarantee.
So anyhow, going back to, signing something, again, the time requirements are set by state statute. State statute also says that, the applicant and the board can agree to an extension. And, again, I first came on the board in '92, and we were always signing something, when there was a
I bet
continuance.
you Jim Whalen came up with that.
Yeah. And it may have been that's something that, I guess, I don't even know if Marie Crimmins was the town clerk then, but it may have been something that town clerk's office was requiring. That's why I said I would want to speak with Bob before I came up with any, suggestions as far as us. And that's all that I have.
Take emotions.
Yep, so next Thursday at 8?
Next Thursday at 8 PM, it's some kind of board and committee training or something. I think it starts at 6, so they're
Yeah.
thinking it'll be over by 7:30. So that's why we couldn't have it until 8.
Is
So-
Lorraine going to that?
Yes.
So if you
Yes.
want to come early and learn whatever they're learning, feel free. If not,
I haven't-
knowledge.
When do we take a motion to adjourn?
Is it going to be on cable? I'll make a motion, we adjourn.
All in favor? Okay. Thank you.